My name is Nomfumdo Jele from the Law Society of South Africa. I'm joined by Elvira Roux, who sits on the Law Society's House of Constituents, and we'll be discussing the Divorce Backlog Project. Welcome, Elvira.
Thank you, Nomfumdo.
Okay, just to provide a bit of background, various stakeholders have agreed to have a divorce backlog project due to the high volume of outstanding divorce cases on the court rolls. The purpose of the project is to fast-track unopposed and settled disputes to get finalized and to fast-track opposed divorces through the possibility of mediation. Here, Elvira, what should an attorney do when he or she does not receive further instructions from the client?
Nomfumdo, an attorney should always make various attempts to get hold of his clients and to obtain proper instructions. He or she should employ all means available to him to contact the client: emails, messages, faxes, letters, even WhatsApp messages. And the legal practitioner should then also keep up a record of all attempts made by the client or by him to contact the client, and keep proper record of those so that if there are any questions asked at a later stage, the records can be available.
Can you give us some examples of good causes for withdrawal?
There's a few good causes for withdrawal. The first and the most common one is if an attorney is sick. Sickness is a good cause for withdrawal. Secondly, if there's failure by a client to pay for the legal practitioner's services, just provided that a reasonable demand has been made for payment by the legal practitioner. Then also if there's a failure by the client to provide the legal practitioner with sufficient instructions to take the matter further. And then fourthly, if there's any circumstances where it might result in unethical or dishonorable conduct for the legal practitioner to continue to represent that specific client. And then lastly, if there's hostility between the client and the legal practitioner, that usually results in a breakdown of the relationship, and the legal practitioner will not be able to continue to represent such a client.
Okay, Elvira, and what happens to the attorney's, to the documents in the attorney's possession?
An attorney has a right to retain all documents that he has expended time and effort on and on which he is entitled to charge a fee. So it might not necessarily be only the document that's been drafted by the attorney. There might also be other documents or items in the attorney's possession relevant to the mandate to the attorney that the attorney will be entitled to retain. Generally, a legal practitioner will have a lien over all the work that he's done until the fees have been paid. Once again, the principles that a reasonable demand for the payment has been made to the client. And then also a court might decide to lift the attorney's lien on condition that a client provides sufficient guarantees or surety for payment of the attorney's fees.
Okay. And are there any relevant standards laid down under the Code of Conduct?
Yes, our Code of Conduct has a few standards laid down for attorneys that might assist us in this. Firstly, 3.11 states that any legal practitioner or candidate legal practitioner should always use their best efforts to carry out client mandates in a competent and timely manner, and that they should not take on any work that they are not comfortable or competent in that specific field, or that they would not have the time to expend on that matter specifically. 3.12 of the Code of Conduct entitles our legal practitioners to charge a reasonable fee for their services, just provided that you are not entitled to refuse to continue to work on a matter if your demand for payment is unreasonable with regards to time or the manner in which you have demanded it. So it should just always be a measure of reasonability to your fees and the time that you allow the client for payment. 9.6 allows a practitioner, if there's any conflicting instructions, and attempt to withdraw earlier instructions given to a legal practitioner, to withdraw because that might cause embarrassment to the legal practitioner. Then the Code of Conduct 57.7 says when there's a withdrawal or in any other circumstances, a legal practitioner is not allowed to disclose any privileged or confidential information from any client. And then lastly, I might just refer to 59.2 of the Code of Conduct, which says specifically in a divorce, legal practitioner is allowed to draw up a settlement agreement whilst representing both parties, provided that he has expressly advised and keep record of that advice, both parties that are entitled to their own legal advisor with regards to the settlement, and also if there's children involved in the specific divorce or settlement agreement, the legal practitioner must make active attempts to ensure that the settlement agreement provides for the best interest of the children and are fair to both parties involved.
Thank you so much for your time, Elvira.
Thank you, Nomfumdo. It was good talking to you.